Hi, welcome to my YouTube channel, The Knowledge Cast, and today's podcast on the recent judgment of the Honorable Delhi High Court in the matter of Samsung Electronics Company Limited, relating to secondment of employees and permanent establishment issue. That is, does the secondment of employees creates a permanent establishment in India? And I am your host, CA.Gaurav Garg, to make you understand more about this judgment. Brief facts for all of you. Samsung Electronic Companies Limited, that is, let's say SEC, we all know is a global electronics giant based out of South Korea, operates in India through two subsidiaries, Samsung India Electronics Private Limited and Samsung India Software Operations Private Limited. So, back in 2010, somewhere in June, the Indian Income Tax Department conducted a survey at the office of Indian subsidiary, that is Samsung India Electronics Private Limited. Following this, they issued a notice under Section 148 of the Income Tax Act to reassess the income of the Korean company, which is Samsung Korea, for the assessment year 2004 5 to 2009 and 10. The department suspected that certain incomes like royalties and there is a potential existence of permanent establishment had escaped assessment. Now, the matter went to the DRP, Dispute Resolution Panel, and wherein the DRP disagreed with various observations of the assessing officer and only concluded that because of the secondment of employees, there is a PE permanent establishment of the Korean company, that is Samsung Korea in India. From there, the matter went to the Income Tax Appellate Tribunal. So, the key issue in this judgment, which was initially analyzed by the tribunal and then later on by the High Court, which is the subject matter of this podcast, is whether the secondment of employees in India creates permanent establishment or not. So whether the secondment of employees create permanent establishment or not. So what basically we need to find out when we are analyzing such kind of a case, that the seconded employees in India, and in this case the seconded employees of the Korean company in India are acting as the representative of the Korean company managing its business in India, that is the business of Samsung Korea in India, or they are functioning as employees of the Indian company, that is Samsung India, wherein the Samsung India is acting as an economic employer for those seconded employees. This distinction is critical. If these employees are deemed as that they are serving the interest of the foreign company, then one would conclude that yes, there is a permanent establishment of the foreign company in India. But if the case is otherwise, that is, if they are not serving the interests of the foreign company, rather they are working for the Indian company, then in such case the conclusion would be that it will not create a permanent establishment. As I said earlier, the matter first went to the Income Tax Appellate Tribunal, and the ITAT analyzed various roles and activities of seconded employees. So what tribunal find out? While there was seamless information exchange between the Korean company Samsung Korea and Samsung India, it related to primarily the Indian operations, that is the operations of Samsung India. Things like understanding consumer preferences, product designing for the Indian market, stock logistics and market strategies, all these things were the seconded employees in India used to take the feedback from the foreign company Samsung Korea, but that was again primarily for the Indian operations. There was no evidence to suggest that Samsung Korea was conducting its business or making strategic decisions such as pricing or product launches through the seconded employees in India. Based on this, the ITAT ruled in favor of Samsung Korea, that is, the seconded employees who were engaged in the business of Samsung India. They were doing the business activities of Samsung India, and this secondment did not create any permanent establishment in India. The revenue went to the High Court, and the Honorable Delhi High Court uh, look into the facts uh, and the decision of the tribunal, decision of the DRP. It also looked into what OECD model convention is saying, what UN model convention is saying, what are the various case laws on this issue earlier, and basically noted that the secondment of technically skilled employees is a common practice in global businesses. The crucial factor one needs to consider is whether these employees are furthering the business of their former employer, and in this case Samsung Korea, or the enterprise they are seconded to, that is Samsung India. Based on the evidence, the court concluded that the employees' activities solely benefited Samsung India and did not contributed to the uh, Samsung Korea's business or income generation of the non-resident entity in India. Based on this, the High Court emphasized the importance of economic employer, where the focus is on who exercises control over the employees and who benefits from their work. And High Court ruled that because of this, because they are involved in furthering the business of Indian entity and the control was also of the Indian entity, the High Court ruled that no fixed place fee is created because of the secondment. So for all of us, the key takeaway is there are 3 points which needs to be remembered. One is, who is the economic employer? If means, who is controlling those employees, whether it's Indian entity or the foreign entity. If it is the Indian entity, there is a risk of permanent establishment is low. For whom they are working, means they are the seconded employees are involved in furthering the business of a foreign entity, or they are involved in furthering the business of an Indian entity. So if they are under the control of the Indian entity and they are working to benefit the Indian entity and not the foreign entity, then most likely the result will come in favor, that is, the secondment will not create a permanent establishment. But yes, one must have the robust documentation to prove that the employment is with the Indian entity and the Indian entity exercises the control over such employees. And this is a very important judgment by Honorable Delhi High Court, and it adds up to the clarity on how secondment arrangement should be evaluated for permanent establishment purpose. I hope you find this discussion informative. Don't forget to subscribe for more updates. Until next time, this is Gaurav Garg signing off. Thank you.